I'm attorney Brian Williams, and I'm going to explain some things regarding preserving legal permanent residence. Legal permanent residence, commonly referred to as a green card, is the immigration status that allows a person to live and work in the United States permanently. It's very important to understand that this status requires the person to actually reside in the United States. It's possible to lose permanent residence, and this is called abandoning residence. There are many legitimate reasons a green card holder may need to be abroad temporarily, such as needing to care for an ill family member, taking a temporary job abroad, studying, or to liquidate assets like a business or real estate. Even though there may be valid reasons for extended visits outside of the U.S., immigration officers at the airport are allowed to question green card holders about whether they have given up or abandoned their status. The officer may ask questions such as, "Where have you been outside of the U.S.? For how long? What were you doing there? Why are you coming to the U.S. now? What ties did you keep to the U.S. during your absence?" If it appears that a person has abandoned their resident status and is not willing to voluntarily give it up, the officer may refer them to an immigration court for a judge to determine whether resident status has been abandoned. There are many myths about how long a resident can stay abroad. The real rule is that a resident who makes trips abroad that are not temporary loses that status. Unfortunately, there is no specific time limit for what temporary means. The Ninth Circuit Court of Appeals has provided the legal immigration definition of temporary visit abroad as when the visit is for a short period fixed by some early event, or the visit will end upon the occurrence of an event having a reasonable probability of occurring within a short period of time. If the length of the visit is contingent on an event that does not occur within a short period of time, the visit will be considered temporary only if the alien has a continuous, uninterrupted intention to return to the U.S. The Immigration and Nationality Act does contain a statute that references trips abroad that are less than 6 months. It is not, however, a safe haven that allows residents to preserve residence by returning every 6 months. The rule says that a resident returning from abroad doesn't count as applying for admission, and officers won't question their qualifications to enter as long as they meet the following requirements: that they have been abroad for less than 180 days, and that they have not abandoned their resident status by making a trip abroad that isn't temporary. What this means is that returning in under 180 days is only one of the requirements. It's also necessary that the trip meets the judicial definition of temporary. If the trip is not temporary, even though it was less than 6 months, residents can be abandoned. The clearest example is a situation where someone lives abroad but who briefly touches down in the U.S. once every 5 months in an attempt to retain residence. That person has abandoned their resident status and should not be readmitted as a resident, despite keeping every trip abroad under 6 months. The safest way to avoid abandonment is to be in the U.S. more than any single other country, sleeping more nights in the U.S. than elsewhere. This is the basic rule that comes from the INA's definition of residence, which means one's principal place of abode, or in other words, one's principal actual dwelling place. If that is not possible, then it's necessary to document with clear evidence that stays abroad are for a clear, temporary purpose and that the resident has retained ties to the U.S. that, in comparison to ties abroad, evidence an intent to return to live here once the temporary stay abroad is over. A resident who is going to have more extensive absences from the U.S. needs a plan to preserve resident status and eligibility for naturalization. That plan may well include deepening and documenting ties to the U.S., clarifying the evidence of the temporary purpose of the stay abroad, and maybe applying for a reentry permit. I recommend that residents with expected extended travel consult with our firm to draw up and guide you in an implementation of resident status preservation plan. If a resident has been outside the U.S. for more than 1 year, their green card is not valid to re-enter the U.S. In this situation, three options include presenting a valid re-entry permit, applying at a U.S. consulate for an SB1 returning resident visa by convincing the consular officer that the stay abroad was temporary and its extension past 1 year was beyond the resident's control, and applying to an immigration officer at the point of entry for a waiver of the green card requirement by proving that the stay abroad was temporary and that there was good cause for not returning within 1 year. A resident should consider applying for a re-entry permit if either they are likely to be abroad for more than 1 year, they are likely to be abroad for more than 6 months straight for 2 or more years in a row, or that they have been warned by an immigration officer that they are at risk of abandonment. Unlike the green card, which is valid for a return after an absence of up to 1 year, the re-entry permit is valid for up to 2 years. There is still no guarantee that a resident with a re-entry permit will be able to re-enter the U.S. The reason is that even with a re-entry permit, the resident must also prove that they haven't abandoned their status. If the trip was for the same temporary purpose described in the re-entry permit application, there's a presumption that the trip was temporary and the resident can be readmitted. If, however, the stay abroad was for a different purpose, then the resident can be referred to a judge to determine whether residence has been abandoned. Many residents are aggressively questioned by officers in the airport on this point. The re-entry permit is obtained by filing Form I-131. The application must be submitted and received by USCIS prior to leaving the United States. To re-enter with the re-entry permit, the resident must be prepared to show evidence that the purpose of the stay was consistent with the temporary purpose stated in the application, and also be prepared to back that up with evidence of the comparative strength of the U.S. ties compared to the ties abroad. If a resident has been abroad for a prolonged period, the immigration officer will recognize that period as temporary only if they've maintained a continuous, uninterrupted intention to return during the entirety of the stay abroad. Since it's hard for the officer to determine what's in a person's mind, the officer will consider the strength of the ties in the U.S. versus ties abroad to see if the ties are strong enough to infer that the resident planned throughout this trip to return to the U.S. For example, they may ask, where do you own or rent property? If you own or rent in the U.S., do you have access to it, and are your belongings in it? Or have you rented it to anyone else? Where do you work or go to school? Where do your close relatives live? Where do you keep your key assets, your bank account, your credit cards, your cars? Do you file income taxes? Are they filed in the U.S. or are they filed overseas? Do you have a valid driver's license? Is that overseas or is it a U.S. driver's license? There are many different questions that we'll ask, and these are some of them. If a resident attempts to enter the U.S. when they are vulnerable to a charge of abandonment, especially lacking a valid entry document, they will need to be prepared with supporting evidence and be ready to answer related questions. The burden is on the resident to show that he is clearly and beyond a doubt entitled to be admitted. A resident making a lengthy trip abroad should also maintain and carry evidence that he or she intends to reside in the U.S. permanently and that the trip abroad was only a temporary one. This can include evidence that the purpose of the trip was temporary, the visit was for a fixed period of time with a fixed end date, any delay in returning to the U.S. was outside of the resident's control, the resident always had the intent to make the U.S. his or her permanent home, such as family ties, income tax returns, and property ownership, membership in any organizations, things like that. While an attorney can help prepare, there's no right for an attorney to be present during inspection at the port of entry. At the U.S. port of entry, officers could perform a brief inspection in line or could take the resident to a separate office for detailed questioning. It's called secondary inspection. Then they could take one of several actions. They could admit the resident to the U.S., or granting a documentary waiver if necessary, refer them to deferred inspection, meaning a later appointment with an immigration officer for further investigation. They could allow the resident to withdraw the application for admission and return abroad, allow them to relinquish their resident status, voluntarily giving up the green card, and to be admitted as a non-immigrant, or they can issue a notice to appear for removal proceedings in immigration court. Notably, those officers do not have the power to take permanent resident status away. Only a judge in immigration court can do that. CPB's Offices of International Affairs operates an immigration advisory program at a number of foreign airports with the mission of intercepting travelers who seek to board flights to the U.S. but who are ineligible for admission. These officers make no board recommendations to airlines and to foreign governments, sometimes based on interviews with travelers and baggage searches. Keep in mind the separate requirements for naturalization. Keeping resident status and preserving eligibility to become a naturalized U.S. citizen are two very different things with different requirements. The residence-related requirements for naturalization include, but are not limited to, the applicant must have been a legal permanent resident for at least 5 years, 3 if married to a U.S. citizen. The applicant must have been physically present in the U.S. for half of that period. The applicant must not have broken the continuity of U.S. residence. Continuity is absolutely broken by a 1-year continuous absence and presumably broken by a 6-month continuous absence. That presumption can be overcome only where there is very strong evidence the absence was intended to be temporary only. Key evidence includes, but is not limited to evidence that the applicant did not terminate his or her employment in the U.S., the applicant's immediate family remains in the U.S., that person retained full access to hers or her U.S. abode, the applicant did not obtain employment abroad. I can help anyone who is at risk at losing their residence. A resident should seek help preparing to preserve their residence if there is a possibility that they will have any extended periods of time away from the United States. It's better to prepare before any travel. If a person has already run into problems because of travel abroad, I'd be willing to help fix that situation as well. Call me at 301-891-8485 or visit my website at www.brianwilliamslaw.com.